whether the legislative party in the House acts independently of the political party. Because I will, Malaj, while I go through the facts before your lordships, indicate to your lordships that on the 21st of June, when the first meeting took place, and we called the group led by Uddhav Thackeray, called members of the legislative party who belonged to now the Eknath Shinde group to come and attend the meeting, which was not done, pursuant to which some actions were taken. The contention throughout has been that there is a split in the party. So the issue before your lordships is, can members of the legislature within the House or comprising of those members of the House by themselves say that there is a split in the party because they don't agree with the leadership? This in turn would require your lordships to look at the 10th schedule and in that context interpret the role of the party within the legislature. Because after all, members of the legislature of any particular party get elected on a symbol of the party. They are there because of the party. And if they are there because of the party, Malaj, there is an umbilical cord link between them while they are sitting in the House and the party outside. Can that link be severed and say, we are an independent set of people, we can do what we like? That will require, Malaj, the interpretation of the 10th schedule. It requires your lordships to analyze the role of the whip, how a whip gets appointed, how he happens to be a bridge between the legislative party and the political party, and that nothing happens in the House without the political party taking a decision. Nothing happens. Mullah, the bill is introduced by the treasury benches, any bill.
So is it your contention, Mr. Sibal, therefore, that unless there is a split outside the House,
yes,
within the political party,
yes,
that split cannot find recognition within the legislative party within the House? That's your...
Absolutely. That's my contention. That's the law also, Mullah, and I'll demonstrate that to your lordship. That is the law. But what happens, Mullah, that I'm giving your lordships an example, Mullah. A bill is introduced by the treasury benches, a controversial bill, let's assume. Bill there in which there is no consensus, Mullah. What happens? The parliamentary party, a group of members of the legislature are invited by the parliamentary party to sit outside the House in a particular room and say, this is the bill that's being introduced, what should be our position? The party decides the position and it's articulated in the House. The legislative party by itself, dehors the party, doesn't decide what we are going to do, what we are not going to do. When a whip is going to be issued, Malad, it's issued outside the House, translated inside the House. Okay, on this, you're going to vote against the bill that has been introduced, or that you will vote in favor, or that you will abstain.
But when the 10th schedule speaks about, say, a merger, for instance, now, there are very few exceptions in the 10th schedule, and it speaks of a merger.
Yes.
Ultimately, the speaker has to decide whether there is a merger. The speaker will not go into whether there was a merger outside the House, because then the speaker will be taking over the function of the Election Commission of India.
That argument is entirely on a different plane, Malad. So we're not dealing with it, and we'll interpret the paragraph 4 for your lordships also.
The speaker's remit cannot lie outside the House.
Malad, there's a problem. Supposing, all right, then let's analyze that for a minute, Malad, since your lordships have raised the issue. Malad, supposing there are 10 members of the legislative party in the House. The merger has to take place of the political party. They belong, say, to the Malads, to the Samajwadi Party, right? Now, even paragraph 4 says that there is a merger of the political party, not the merger of the legislative party.
Right.
Right? So, therefore, Samajwadi Party has
argument. But no, if you accept your argument, that would mean that unless the Election Commission of India decides on a merger outside the House, the Speaker cannot take a decision within the House.
Election Commission did not.
Whether there is a merger or not, that can't be.
No, Election Commission did not decide this issue.
How else?
Because a resolution will be passed that we have merged, and that will be informed. The Election Commission, they don't take a decision. They'll be informed. Majority of the members of the party will decide. They'll be informed. Once merger takes place, these eight people may say, we don't want to merge. And paragraph 4 says they need not merge. But I'll come to that later. This is a very complex issue. Not so.
Let's have a broad now framework of the facts, because
I will, Malaj.
In fact, that was our basic problem there. Unless we have a clear perception on the facts, it's very difficult for us then to look at the law divorced from the facts.
I entirely agree, but just, may I just, Your Lordship, what are the issues that are going to be? I just told Your Lordships two.
We have to necessarily reframe the issues, because the issues which are there, which are
Yeah, it's not reflective of what needs to be decided. I agree entirely. The other issue is, and that's never come up before the court, and that issue is, can a governor swear in a member of a legislative party against whom a disqualification matter is pending before the House? That's the other issue. Never come up before. What then are the powers of the governor in matters in relation to disqualification? This is not a case of a pre-poll alliance. This is not a case of a post-poll alliance. This is not a case of one political party. It is a case of people who allege that they are the party because they are a majority in the legislature. Right, Mullahs? What then are the powers, or what should be the function of the governor in matters of this nature, and how he should conduct himself? Because he also knows, because the disqualification petition is pending, Mullahs. He also knows. And if the governor does, Mullahs, swear him in as a chief minister, Mullahs, he actually topples a democratically elected government and aids in doing that because they happen to be majority in the legislature. Well, that's one of the issues that Your Lordship may have to consider. The other issue to be considered is, can a court, constitutional court, without referring the matter to the Speaker in the facts and circumstances of this case, decide the matter on its own, given the fact that there are no disputed facts? We are not going to, Mullahs, place before Your Lordships any disputed fact. All are matters of record.
Your question is, can a constitutional court decide 10 schedule?
That's correct.
10 schedule.
Yeah, that's correct. That's correct. Because under the 10th schedule, it has the Speaker to decide, Mullahs. But if the proceedings, Mullahs, are imbued with illegality, and given the conduct of speakers in the past, what then should be the attitude of the court in a given matter? And then, of course, lastly, Mullahs, how do you deal with an issue? And that, Mullahs, because the last question in the reference is the powers of the Election Commission. And Your Lordships, and that's the last question, which is the last issue Your Lordships will have to decide, that under paragraph 15 of the Symbols Order, when there is a split in the political party, it starts with that proposition, that two factions have arisen pursuant to a split in the political party. Then which faction should get the symbol?
Will that arise in this case?
I'm sorry?
Will that arise here?
Yes. That's a question. That's a question. What is the role of the Election Commission in matters that's part of the reference.
So under paragraph 15 of the Symbols Order, when two factions emerge in pursuance of a split.
Yes.
So what is the sequitur? How would you end the sentence?
Well, then what is the role of the Election Commission in deciding that matter? Should it await the decision of the Constitutional Court? Should it go ahead? Your Lordships only, Mullahs, as Your Lordships will remember, in September said no stay. But Your Lordship did not say how he is going to decide it.
But that, Mr. Sybil, is your independent challenge to the order of the Election Commission.
That's a separate issue, Mullahs.
We can't really decide.
No, that's part of the reference, Mullahs. I'm going to argue, Mullahs.
How do we...
Constitutionally, the Election Commission cannot proceed. Mullahs, the split would have to happen on 21st of June. There was no whisper of a split on 21st of June.
Your contention that therefore the Election Commission itself cannot proceed until the Speaker has decided.
Correct. That's what Your Lordship said. No stay, fine, Mullahs. No stay. We went before the Election Commission and said, you cannot decide this matter. The matter is pending in Supreme Court. He said, no, but Supreme Court said no stay. And you will find that tomorrow, Mullahs, when Your Lordship sit at 3:30. But that's the last question that Your Lordships, Your Ladyship will have to look at. So these broadly, Mullahs, are the issues that you might be asked upon to decide, Mullahs, that you might wish to decide. Mullahs, it really doesn't clarify what it means. What is the status of proceedings? What it means is that can members against whom there is a disqualification petition pending have a role to play in the House while it is pending? Otherwise, you can topple any government you want. Now, this question only arises if you allow proceedings to go on. If you don't decide on the disqualification before, then this question arises, because if at a later point in time, you consider them to be disqualified relating back to the date when their act led to a voluntary giving up membership of the party or violation of the whip, then what happens to the intervening proceedings? A government has been formed, actions have been taken, policy decisions have been made. Would it not be better for the purposes of, I personally believe, democratic traditions, that you should await your hands till the disqualification is decided first, because this problem will not arise then. Then, F, I think is very, very important. What is the impact of the removal of paragraph 3 in the 10th schedule? According to me, that's central to the entire issue. Because now you don't have a split. The issue of a split doesn't arise. Which is why, if you want to go to the election commission, there has to be a split in the party, not a split in the legislature. That is not on record. No such split. So this is central, and we'll interpret paragraph 4 also in that context. Well, it's actually, again, convoluted in its expression. In simple terms, it means that how is a whip appointed and how is a leader in the house appointed? Is there a role of a political party, or is it something that the legislative party decides? Can majority of the legislative party decide I'll change the whip tomorrow? So what has happened in this case, and I'll come to the facts, that sitting outside the house, X number of people said you are no longer the whip. And those are members of the legislature only. I can give your lordships documents to the effect. What happens is, when a leader of the house is appointed, the letter that is given to the speaker is that the party hereby decides that this person will lead the house for the party. It's not the members of the legislature don't decide these issues. Similarly, whip, because the whip is the bridge between the government or the opposition, whichever party it is, and the house, members of the legislature. That's why your lordships will see that nowhere in the constitution does the word political party is referred to, except in the 10th schedule. So, what will happen is, that it will be fixed in the house within 7 days as an item on the agenda, resolution of moving. Still such time, the resolution is actually, Speaker is conducting his affairs in the assembly. He is not prohibited either under the constitution or the rules of business not to sit in that chair, even though there is a motion, there is a notice, and there is leave. He only vacates his chair at the time of voting. So, the assembly goes on, but the 10th schedule is paused, constitutionally paused by this judgment.
And it is after leave is granted that the motion has to be then taken up within a period of 7 days.
That's right.
So the first threshold, really, I was just reading Rule 11, says that the motion to remove the speaker is to be given, of which 14 days notice is required under Article 179. That's the Article 179 threshold.
That's correct.
That is given. Then, as soon as maybe after the expiry of that 14 days notice period, it would be read to the assembly by the speaker. The speaker said, well, those who are in favor should rise. If 29 people rise, then leave is granted.
Yes.
And then within 7 days thereafter, a motion
Absolutely.
to remove
That's the process.
That's the process.
That's the process.
Part of it is constitutional, the 14 days requirement.
Right.
But the rest of it is legislative assembly procedure. Of course, that's also rules made under the Constitution.
That's correct.
Now, Nebium says that the moment the notice is given by an individual, you are then disabled. The speaker is disabled from functioning.
As a tribunal, not otherwise in the assembly.
He performs all his
functions in the assembly. So how can you have an interpretation of the constitution where the speaker against whom there is a notice for removal functions in the assembly but can't function under the 10th schedule?
So according to you, at what point of time is the disability attached to the speaker?
There is no disability.
There is no disability according to you.
No.
Even after the 29 threshold is crossed and leave is granted to move a resolution, according to you, there is no...
There can't be, Mother. Still can't be, because the resolution may never be moved.
Unless the resolution is put to motion, put to vote.
Exactly. And the reason is why there cannot be no hiatus. Because there must be somebody in the tribunal to deal with disqualification petition. So you can't say that between the leave and the resolution he should not function. Because the constitution doesn't allow a pause for us in the functioning of constitutional authorities.
Once leave is granted, Mr. Sibal, the discretion to move the motion is still with the member who is moving the motion.
Yes.
So he may not move the motion at all.
Do not move it.
Is it that after the leave is granted within certain days, the motion is to be moved?
7
Actually,
days. 7 days. 7 days.
7 days.
Suppose it is not moved by the concerned, it will lapse.
Absolutely.
But if he stands by his motion,
Yes.
the speaker has no option but to move it list it within 7
Then
days.
Article 181 says you must actually move from the chair, become the. Well, then what happens? Very interesting. The
Can
Constitution.
we just see? I mean, let's keep never mind. Let's look at the constitution for
Yes.
a second.
179.
It's always better to apply our
Always better. Always better. I agree.